Let us start by deconstructing a common belief about patents. Patents do not always equal to innovation. In the field of software, we have experienced that patents are actually used as weapons of economic war, hinder innovation, and create a potential threat on every vendor, developer, and user of software.
I work long hours. I work all day.
We are not the only ones to say this. Actually, the vast majority of software professionals are opposed to software patents.
If software patents were really doing their job, you would expect that they would encourage more innovation, and they didn't. In fact, there's evidence suggesting just the opposite.
In the United States, the observations of the effects of software patents in the last 20 years showed how detrimental they are to the economy. Most software firms still do not patent, most software patents are obtained by a few large firms, and the risk of litigation from software patents continue to increase dramatically. These particular concerns about software patents mean that globally, patent policy has to be taken carefully. A bad patent policy could be disastrous for the innovative economy and for the fundamental rights and freedoms. Fortunately, in the European patent law, software is explicitly excluded from patentability. It is important to note that in Europe, patent law is governed by the European Patent Convention, the EPC, a multilateral treaty that led to the creation of the European Patent Office, the EPO. Thus, the EPC is not European Union law, and the EPO is not a European Union's agency. Unfortunately, against the spirit and the letter of this law, the EPO has started in the 80s to grant patents on software, arguing that the law does only prevent patentability of software as such, but that some software has actually technical effects and shouldn't be regarded as software as such, and is therefore patentable. The result of these dubious practices is that we have now in Europe tens of thousands of very strong monopoly rights, not covering the source code of software, that is what copyright is for, but over the very functionalities of software, over algorithms, that is mathematics, over data processing ideas. But it could have been worse. In 2005, thanks to a massive grassroots effort, the European Parliament has rejected a directive aiming to legalize the EPO's practices of granting software patents. After this rejection, even if the EPO continues to grant software patents, courts are still free to declare them invalid. The next attempt was to replace national patent courts with a unified central court governed by the EPO. Fortunately, this attempt has also failed, mainly because it would have been contrary to the EU treaties for member states to build up such a court on their own without the EU being part of the project. These failures have highlighted that the issue is actually systemic. The EPO is functioning inside some kind of a bubble for the sole interest of a patent microcosm, composed by patent lawyers and patent departments of some mainly non-EU big firms. And as usual with bubbles, the EPO is geared towards an unlimited expansion of its bubble. The more patents it grants, the more wealthy is the EPO.
Democratic.
So, there is a need to refocus the European patent system in the interests of European economy and society as a whole. Actually, even the highest internal quasi-judicial body of the EPO, the Enlarged Board of Appeal, has called for the only way to achieve this. Legislators should act. Indeed, the EU is working for decades to reform the patent system. Currently, once granted by the EPO, a European patent comes finally into existence as a bundle of national patents in each country designated by the patent applicant. And each of these national patents has to be translated and is subject to some fees to each and every national patent office. Moreover, to prevent allegedly infringements of a European patent, or conversely to invalidate such a patent, one has to file lawsuits before each and every national jurisdiction.
On a church.
So, the EU wants to set up a new patent title that would have unitary effect throughout the whole Union, and that would be enforceable before a unified patent court.
The spinach.
But member states of the EU haven't managed to reach an agreement about the linguistic regime of the unitary patent, whereas this issue requires unanimity. So, it has been decided to use a procedure called enhanced cooperation. One EU regulation has to be voted by the European Parliament and by countries of the Council which are participating to this enhanced cooperation. In the case of the unitary patent, all EU countries are participating, but Spain and Italy. Then, the European Court of Justice, the ECJ, smashed the project of a unified patent jurisdiction because it was outside of the judicial and legal framework of the EU, sending the European Commission back to the drawing board. Also, a unified and specialized patent jurisdiction suffers from the example of the United States, where the Court of Appeal for the Federal Circuit, the CAFC, has shown to behave in an excessively pro-patent direction, broadening the scope of patentable subject matter and endowing patentees with unwarranted power. This ever-growing desire of the CAFC to expand its powers has started to be criticized not only by economic and legal scholars, but also by the US Supreme Court. This implies that whatever patent jurisdiction is set up, its ruling shall be subject to an overview by an independent court that is able to weigh proportionally conflicts between patent law and lower legal areas, such as competition law or fundamental rights and freedoms. And actually, since the opinion of the ECJ already mentioned above, there is no other choice. The EU should also make sure that it has the full power to decide about what should be excluded from patentability, what conversely can be patented, and under which requirements. A good patent policy has to be shaped to encourage innovation, while a bad patent policy could lead to a derailed system. And this choice cannot be left to the patent microcosm.
In this here.
Unfortunately, the Commission's proposal for a regulation of the unitary patent does not follow this path. On the contrary, the proposed regulation does not create an EU patent, but just use the traditional patent granted by the EPO with a special unitary flag, meaning that the validity of such a patent should be considered throughout all participating member states. And the EU would not be part of the agreement setting up a unified patent jurisdiction. Instead, this court would be common to all participating member states. Moreover, the Commission's proposal for a regulation of the unitary patent is actually raising questions about the validity of its legal basis.
On a churchyard or in our shoes, old tennis shoes. This is the list.
the Spanish and Italian governments have already challenged the decision to operate through the enhanced cooperation procedure before the ECJ, and they have pledged to similarly challenge the regulations implementing this enhanced cooperation. It follows that some amendments to the proposed regulation are required. First, it should be made clear that the unitary patent is a patent title of the EU, just as stated by the legal basis in the EU treaties. Second, references to the provisions of the EPC used to flag the usual EPO patent should be deleted. Third, would the unitary patent be granted by the EPO, the EU should explicitly define this delegation of powers. Additionally, rules of the EPC used for granting unitary patents should be deemed to be liable in the same condition as if such acts have been exercised by an EU agency. Finally, the regulation should clarify provisions of the EPC related to what should be excluded from patentability, what conversely can be patented, and under which requirements. This can be done either by planning a separate legislation or by clarifying main provisions inside the regulation on the unitary patent, or, for the special issue of software patents, by directly stating that they should be excluded. The bottom line is that the regulation on the unitary patent is all about the degree of autonomy the EU wants to leave to the EPO. The Commission's proposal is obviously too much EPO-centric, expanding the patent bubble. We have proposed a set of amendments that would give back to the EU the necessary democratic control over its innovation policy. Support these amendments.
Power to the parliament if it's democratic.